Aloha, I'm Mary Bergère, Executive Committee Liaison and a member of the Government Affairs Committee for the Hawaii Association of Realtors. Every legislative session, we work on behalf of yourselves as realtors, our homeowners, and our communities. Today we're going to talk about seller financing. So what is seller financing? Seller financing is owner financing. Sometimes it's referred to as a land contract or a carryback. Purchase money first mortgage, purchase money second mortgage. That's seller financing. It's when the seller acts like the bank. Why would the seller want to act like the bank? Well, sometimes they prefer to have the steadfastness of an income on a monthly basis rather than a balloon or lump sum payment at closing. Why would a buyer want to do that? Why wouldn't a buyer want to go to the bank today when they have such low interest rates and get a 30-year fixed mortgage? Possibly the buyer's not in a position either credit-wise or in their job, they haven't been in it long enough, all kinds of things that come up in the qualifying process that a seller is able to be more flexible about. It might also just be that the property doesn't qualify. You know how we are here in Hawaii, sometimes we've got a few little building permit issues, or maybe there's some zoning things going on that just make it difficult under today's compliance rules for a traditional lender to provide the financing. That's when seller financing is appropriate. So why am I talking to you about seller financing like it was something new? Because we've done seller financing in the past? Actually, seller financing was taken away from us as a tool by the 2014 legislative session. The legislature passed a law that removed the exemption from licensing laws that allowed sellers to do owner financing. When HAR found out about that, we introduced a bill in the 2015 session. We got the bill passed so that you can once again ask your sellers if they'd like to do owner financing. However, it's not exactly as liquid and easy to do as it might have been in the past. This law does have some strict disclosure requirements and some specific items and things that the seller must do and disclose to the buyer to comply with the law. So please read the fact sheet that's been provided. Talk to your principal broker, check with your attorneys, have your sellers check with their attorneys, as well as any buyer entering into seller financing. But at least the law is once again in place, so you can do owner financing.
Aloha, I am Nathan Aipa with the law firm of Pitluck, Kido & Aipa. We serve as General Counsel to the Board of Directors for the Hawaii Association of Realtors. I also serve as counsel for the Standard Forms Committee. This year, the Hawaii State Legislature adopted Senate Bill 756 relating to the Secure and Fair Enforcement for Mortgage Licensing Act, which the governor passed into law as Act 225. This new law affects seller financing. 756 emanates from the federal Secure and Fair Enforcement Mortgage Licensing Act, or Federal SAFE Act. It affects seller financing. Hawaii adopted the SAFE Act recently and codified the same as Chapter 454F in the Hawaii Revised Statutes. I'll cover a little more of this soon. Today, seller financing is a highly regulated area. In the recent past, HAR Purchase Money Mortgage Addendum RR 205 and the Agreement of Sale Addendum RR 203 were used as tools by agents to propose seller financing as an alternative means to conventional financing in order to facilitate a sale of a home. Agents may have assisted the buyer or the seller in completing portions of these addenda, which included the amount of the loan, the interest rate, and perhaps the maturity date, and so forth. These addenda might have been included with the purchase contract as being offered by the buyer. Eventually, these addenda were used to guide an attorney in the preparation of the actual promissory note and purchase money mortgage or agreement of sale between a buyer and seller. Today, federal and state laws, rules, and regulations have imposed a greater responsibility on the seller in providing seller financing in order to avoid being licensed or being required to comply with the licenses affecting loan originators. In light of these new, highly regulated legal landscapes, agents should consider the following 6 practical tips. 1. Agents must be reminded to avoid the unauthorized practice of law. Agents should advise their clients, either buyer and or seller, to seek qualified professional assistance, including but not limited to attorneys, financial and tax advisors, a banker perhaps, and perhaps even an appraiser, in completing either the PMM Addendum RR 205, which today has incorporated changes based upon the new law, Senate Bill 756, or the Agreement of Sale Addendum RR 203. Agents must not fill in any parts of these addenda unless they are absolutely sure of what they're doing. Agents may consider including the proposed principal amount and interest rate that applies under the PMM addendum, or the Agreement of Sale Addendum, but leave the rest to qualified professionals who can properly advise their clients on the pros and cons, the tax, the legal, the financial, the valuation issues involved with a PMM or an agreement of sale. When in doubt, agents should consult with their principal broker or their broker in charge when using and completing or advising their clients regarding the PMM addendum or the agreement of sale. As I mentioned earlier, the legal landscape regarding seller financing has become more complicated. In 2008, the federal government enacted the SAFE Act. In 2009, Hawaii enacted its own SAFE Act under Act 32. Act 32 included an exemption in seller financing for individuals who wish to sell their own homes or the homes of an immediate family member. Later in 2014, Act 198 repealed or erased the seller financing exemption. Fortunately, this year, 2015, with the assistance of HAR, Act 225 reinstated the seller financing exemption. But the seller financing exemption under Act 225 includes specific conditions which must be met by the seller in order to be exempt under the new law. What complicates the situation further is that under the Frank Dodd Wall Street Reform and Consumer Protection Act, which was enacted in 2010, Frank Dodd amended the Truth in Lending Act and established the Consumer Financial Protection Bureau, or CFPB, in creating new rules that affected seller financing, which were released January 20th, 2013, and which became effective January 10th, 2014. I would draw your attention to the NAR's publication entitled Impact of Loan Originator Final Rules on Seller Financing, published February 8th, 2013, for further details regarding the Dodd-Frank Act under TILA and CFPB. Act 225, signed by the Governor on July 9th, 2015, went into effect immediately. The Agreement of Sale Addendum and the Purchase Money Mortgage Addendum, prepared by the Standard Forms Committee, have been revised pursuant to this new law. Act 225 is codified as Section 454, subsection 2, parens 10 of the Hawaii Revised Statutes. To demonstrate the complexity of the requirements that must be met before a seller exemption applies, I wanted to list for you some of the requirements involving the exemption. Number 1, a seller must be a person, estate, or trust that transacts 3 or fewer residential mortgage loans in 1 calendar year. The seller will not be deemed a loan originator, provided the seller complies with federal law under sections 12 CFR 1026.36. Again, you can refer to the white paper on the website for further details. The seller must not have acted as a construction contractor for the residence being sold, and the interest rate being used cannot exceed the usury rates under state law. The seller must provide the buyer with a current title search, which is usually done at the time the purchase contract is put into escrow. In addition, the seller must provide buyer with the following financing terms, including the interest rate, monthly principal and interest payments, any prepayment penalty, any late payment charges, the total amount of interest that the mortgagor or buyer will pay over the term of the loan, a calculation of projected aggregate monthly payments including principal and interest, estimated closing costs. The seller's contact information must also be included, meaning his or her address, phone numbers, electronic emails, and alternate contact information to the extent available. The loan must also include a representation that the seller will have a security interest in the buyer's dwelling, and that the buyer may lose the dwelling in the event the buyer fails or defaults on the loan. There is a disclaimer language that must be included with the financing as well, and you can find that specific language in the white paper on the website. Finally, the residential mortgage loan must be recorded with the Land Court or the Bureau of Conveyances as applicable. As I mentioned, the legal landscape for seller financing has become much more complicated. Senate Bill 756, enacted as Act 225 this year, allow for seller financing provided certain conditions have been met. Agreement of sales, while not covered by Act 225, are still covered by federal law under the Truth in Lending Act and rules and regulations enacted by the CFPB. My closing comments involve, again, following 6 practical tips. 1, agents must avoid the unauthorized practice of law. This is a much more complicated area. 2, agents should advise their clients, whether buyer and or seller, to seek qualified professional assistance where necessary, including attorneys, financial, tax advisors, a banker, and even an appraiser when completing a PMM addendum, RR205, or Agreement of Sale addendum, RR203. Agents may use these addenda as a checklist to cover the many elements that must be included and considered by the seller and buyer when developing or using a PMM or Agreement of Sale. Agents should not fill in any of the blanks in these forms unless they're absolutely sure of what they're doing. Agents may consider using or inserting a proposed loan principal amount and interest rate after proper consultation to initiate the discussions between the parties concerning the use of a PMM addendum or an Agreement of Sale. Lastly, if the agents have any questions or concerns regarding the use of the revised PMM addendum, RR205, or the Agreement of Sale addendum, RR203, they should seek assistance and direction from their principal broker or their broker in charge. Thank you.